In the late 80s, a Charleston public hospital was alarmed by the number of pregnant women showing up with cocaine in their bloodstreams. The hospital started screening the urine of maternity patients, referring those who tested positive to counseling. When that didn't help, the hospital called the cops. This landed it in front of the United States Supreme Court in the Fourth Amendment case Ferguson versus City of Charleston. The hospital created a policy under which certain pregnant patients would be tested for cocaine. The urine would be managed in a careful chain of custody. Patients testing positive could undergo treatment, but if they didn't, the police would be notified. A patient could then be arrested and charged with offenses including possession, distribution of drugs to a person under 18, in this case a fetus, or unlawful neglect of a child. Crystal Ferguson and several other women who were arrested after testing positive for cocaine sued the city, alleging that warrantless, non-consensual drug searches conducted for criminal investigations were unconstitutional. The city countered that the patients had consented to the searches and that the searches were reasonable because they were justified by special needs unrelated to law enforcement. The district court found that the searches were unreasonable, but that the patients had consented to testing. It ruled for the city. The Court of Appeals for the Fourth Circuit affirmed, but not on the consent issue. It held that the women hadn't, in fact, consented, but the searches were reasonable under the special needs exception because protecting the health of mothers and children and reducing medical costs outweighed the minimal invasion of privacy. The women appealed, and the United States Supreme Court granted cert.